What will happen to Donald Trump if LA proves ICE raids broke federal law? Donald Trump has always tried to portray himself as the law and order president. But what happens when the law turns on him? New reports out of Los Angeles suggest that ICE raids conducted under Trump's direction may not just have been brutal and controversial, they may have actually broken federal law. Think about the stakes here. If the evidence holds, it's not just about bad optics or political fallout. It could open Trump up to criminal liability, lawsuits, and a fresh wave of accountability that goes far beyond the courtroom dramas he's already drowning in. The same tactics he used to project power could end up being the very tools that bring him down. So the big question now is, will these revelations finally tip the scales of justice against him, or will he once again find a way to slip through? Stay tuned as we break it down right now. When we ask what will happen to Donald Trump if Los Angeles proves that his administration's ICE raids broke federal law, we are not asking a minor procedural question. We are opening the door to one of the most explosive intersections between executive power, civil liberties, and the rule of law in modern American history. The allegations are not about paperwork mistakes or bureaucratic missteps. They are about militarized federal agents in plain clothes grabbing people off the streets, sometimes U.S. citizens, sometimes children, without warrants, and detaining them in ways that legal scholars and judges have already flagged as unconstitutional. If Los Angeles succeeds in proving this conduct in court, the implications for Trump go far beyond immigration policy. They touch directly on presidential accountability, criminal exposure, civil liability, and the political narrative that has followed him since leaving office. The video evidence and testimonies emerging from Los Angeles paint a grim picture. Families describe agents in masks tackling people, detaining a 15-year-old student with disabilities, and even holding a U.S. citizen for days despite her protests and documentation. City Attorney Heidi Feldstein Soto has joined a coalition of 22 jurisdictions in suing the federal government, alleging that these raids violated constitutional rights and ignored court orders. Judges have already issued temporary restraining orders, citing violations of long-standing legal principles, including the Posse Comitatus Act, which prohibits using military forces for domestic law enforcement without authorization. This introduction frames our central inquiry. If the courts conclude that Trump's administration engaged in illegal raids, what consequences await him personally? To answer that, we must first examine the factual record of what happened in Los Angeles, then consider the constitutional framework, analyze Trump's potential civil and criminal liability, and finally assess the political ramifications. The most striking aspect of the Los Angeles raids is how they unfolded in public spaces. Witnesses describe agents waiting in bushes outside courthouses, leaping out in plain clothes, and snatching individuals without identifying themselves. In one incident, a high school student with disabilities was mistakenly detained because agents thought he was affiliated with MS-13. His mother recounted his breakdowns afterward, his constant fear, and his sense of harassment by his own government. Another case involved Andrea V., a U.S. citizen working as a production coordinator. She was slammed to the ground, arrested, and held for 2 days. Even after showing her driver's license, real ID, and health insurance card, agents refused to release her. She recalls being denied water for 24 hours and forced to buy utensils just to eat. Her case was eventually dismissed, but the psychological and physical harm lingers. Then there was the targeting of David Huerta, president of California's largest union, who was effectively kidnapped in these raids. Add to this the countless testimonies from Latino residents of East Los Angeles who were profiled based on skin color or accent, often shouted down by agents when they protested their U.S. citizenship. These are not isolated incidents. They represent a pattern of militarized enforcement that city officials, including the Los Angeles city attorney, have characterized as disproportionate, unconstitutional, and deliberately intimidating. The Department of Homeland Security, under officials loyal to Trump, justified these operations by claiming Los Angeles would have been burned down without them. But local leaders, including Feldstein Soto, called that claim preposterous. Los Angeles has handled massive protests before, from the 1992 riots to the 2020 George Floyd demonstrations, without federal militarization. The evidence suggests that Trump's deployment of 4,000 federal troops and 800 Marines was less about law enforcement and more about political theater, creating fear, staging displays of control, and demonstrating toughness in immigrant communities. The constitutional issues raised by these raids are vast and serious. First, there is the Fourth Amendment, which protects individuals from unreasonable searches and seizures, arresting citizens without warrants, refusing to identify officers, and ignoring valid identification directly violate this protection. Second, the Fifth and 14th Amendments guarantee due process and equal protection. Detaining U.S. citizens and lawful residents without cause, or profiling individuals based on ethnicity or skin color, strikes at the heart of equal protection. Third, the Posse Comitatus Act, rooted in the post-Civil War era, explicitly limits the use of the military for domestic law enforcement. Yet Trump's deployment of Marines and federalized troops to Los Angeles appears to cross that line. Judges have already noted that using external troops to suppress protests and enforce immigration laws without local consent is unconstitutional. Fourth, there is the principle of federalism. Local governments, not Washington, retain primary responsibility for policing within their jurisdictions unless they request federal aid. Los Angeles never asked for these deployments. Instead, Trump's administration imposed them, disregarding both state sovereignty and local authority. Finally, there is the separation of powers. Courts issued restraining orders prohibiting racial profiling and unconstitutional detentions, but Trump's agents continued the raids. Ignoring judicial orders is not merely controversial, it is contempt of court. If proven, it amounts to a direct assault on the judiciary's role as a co-equal branch of government. These constitutional violations, if confirmed, would not simply tarnish Trump's immigration record. They would expose him to potential liability and set precedents about the limits of presidential power. Now we come to the core question: what could happen to Donald Trump himself if these violations are proven? There are several possible avenues. First, civil liability. Victims of unlawful raids, citizens like Andrea, minors like the detained high school student, and community leaders like David Huerta could bring lawsuits under the Bivens Doctrine, which allows individuals to sue federal officials for constitutional violations. While Trump as president enjoyed broad immunity for official acts, that immunity is not absolute. Courts are increasingly willing to examine whether presidential actions that blatantly disregard constitutional protections can be shielded. Even if Trump avoids direct liability, his administration's actions could subject him to depositions, subpoenas, and reputational damage in civil suits. Second, criminal exposure. Ordering federal agents to ignore court orders could qualify as obstruction of justice or contempt. While traditionally presidents are not prosecuted for policy decisions, the deliberate use of federal power to violate restraining orders edges closer to criminal territory. After leaving office, Trump no longer enjoys the same Justice Department policy protections against indictment. If prosecutors determine that his directives amounted to conspiracy to deprive individuals of their civil rights, a crime under federal law, Trump could face charges. Third, congressional accountability. While Trump is no longer in office, a proven record of illegal raids could fuel new investigations into abuse of power. Congressional committees have the authority to revisit his conduct, especially if victims and city officials testify under oath. Such hearings would amplify political consequences, reminding voters of Trump's disregard for the Constitution. Fourth, reputational damage in ongoing legal cases. Trump already faces multiple criminal indictments and civil trials. A judicial finding that his immigration raids broke federal law would reinforce a broader narrative that he is a leader who ignores rules, disregards courts, and uses state power as a weapon. Judges presiding over unrelated cases could take notice of this pattern when considering his credibility or intent. When evaluating what might happen to Donald Trump if Los Angeles proves these ICE raids broke federal law, the question inevitably turns to precedent. History offers limited but meaningful guidance. Courts have long held that executive power, even in areas of immigration and national security, is not unlimited. One of the most relevant precedents is Youngstown Sheet and Tube Company via Sawyer, 1952, where the Supreme Court struck down President Truman's attempt to seize steel mills during the Korean War. The court emphasized that presidents cannot unilaterally ignore statutory and constitutional limits, even when invoking broad national security rationales. Trump's defenders might argue that immigration enforcement falls under executive authority, but Youngstown reminds us that the president cannot simply bypass Congress and the courts. Another precedent comes from cases addressing racial profiling and due process. In United States versus Brignoni-Ponce, 1975, the court ruled that Mexican appearance alone cannot justify immigration stops. The Los Angeles raids, which targeted people based on skin color and accent, echo the very practices struck down in Brignoni-Ponce. If proven, Trump's ICE operations would be in direct violation of this established precedent. There is also the line of cases surrounding contempt of court. The judiciary relies on compliance with its orders. When executive officials ignore injunctions, they not only break the law, but also threaten the separation of powers. Historically, courts have been cautious about holding presidents in contempt, but they have not hesitated to hold cabinet officials or agencies accountable. If Los Angeles succeeds, Trump could be implicated indirectly, with subordinates facing penalties and the chain of command linking back to him. Finally, the Posse Comitatus Act has rarely been tested in modern courts, but its principles remain strong. Using federalized troops and Marines in Los Angeles without state consent could be ruled a violation. If so, it would mark one of the first times a federal court formally limited presidential deployment of troops for domestic enforcement since Reconstruction. Such a ruling would not only damage Trump, but also constrain future presidents. Beyond the courtroom, the political consequences could be immense. Trump's brand has always been tied to toughness on immigration, promising to crack down on undocumented residents and Project Strength. For his supporters, these raids were framed as necessary law and order. But if a federal court confirms they were illegal, that narrative collapses. Instead of appearing strong, Trump would appear reckless, lawless, and abusive. For Latino communities, particularly in swing states like Arizona, Nevada, and Texas, such a finding would deepen distrust of Trump and the Republican Party. Stories of U.S. citizens tackled and detained could resonate far beyond Los Angeles, fueling activism and turnout against him. For moderates and independents, the image of a president defying court orders and deploying troops against his own citizens could reinforce fears of authoritarianism. Trump's critics have long accused him of aspiring to dictatorship. A proven record of illegal ICE raids would provide tangible evidence. Campaign ads could write themselves, video clips of masked agents, terrified children, and Trump speeches defending the operations. Internationally, the fallout would also matter. America presents itself as a beacon of rule of law and democracy. If courts confirm that a U.S. president ordered unconstitutional raids, allies may question America's credibility. Autocratic regimes could use Trump's actions as propaganda, claiming the U.S. has no moral high ground on human rights. Finally, within the Republican Party, the impact could be complex. Hardline supporters may double down, dismissing the courts as biased. But party strategists looking at suburban districts and diverse states would see a liability. Every reminder of Trump's disregard for constitutional protections alienates voters the GOP needs to win. A proven case against Trump would not only affect him personally, it would reshape the national debate about civil liberties and national security. Since September 11th, administrations of both parties have expanded executive power in the name of security. But Trump's Los Angeles raids would represent a line-crossed militarization of domestic law enforcement in defiance of court orders. If courts strike down these raids as illegal, it would reaffirm that national security cannot justify everything. The Constitution still protects against unreasonable seizures and racial profiling. Local communities retain authority over policing. Courts remain the final arbiter. It would also highlight the danger of blurring immigration enforcement with militarization. Immigration agents are not soldiers. Deploying Marines and troops to detain protesters or suspected immigrants creates confusion, fear, and abuse. If proven unlawful, Trump's conduct would force Congress and future presidents to clarify boundaries, perhaps revisiting the Posse Comitatus Act or strengthening protections against federal overreach. For civil liberties advocates, a victory in Los Angeles would be historic. It would vindicate years of warnings that unchecked executive power threatens democracy itself. It would empower local governments to resist federal intimidation. And it would remind the public that constitutional rights apply to everyone, citizens and immigrants alike. The coalition of 22 jurisdictions led by Los Angeles is also central to this story. By intervening in lawsuits, filing motions for injunctions, and testifying about harms, these cities are asserting their power against federal overreach. If they succeed, it would be a rare but important example of municipalities shaping constitutional law. Local leaders like City Attorney Heidi Feldstein Soto argue that their residents suffered real harm. Businesses shuttered, 911 calls spiked, and communities lived in fear. To them, Trump's raids looked like kidnappings, not lawful enforcement. By taking this fight to court, local governments are reclaiming their authority to protect residents and enforce their own policing standards. If they win, it could encourage other cities to resist federal policies they deem unconstitutional. Sanctuary cities could cite Los Angeles as precedent for blocking unlawful detentions. States could feel emboldened to push back against future federal overreach, even in areas like environmental or health regulations. For Trump, this dynamic is dangerous. It reinforces the image of a president not only at odds with his political opponents, but also with the very communities he governed. It frames him as someone who used Washington's power to impose on local neighborhoods without consent. And if judges side with cities, it places Trump on the losing end of a constitutional showdown. So, what will happen to Donald Trump if Los Angeles proves ICE raids broke federal law? The answer is layered. In the courts, he could face civil liability, criminal exposure, and a legacy-defining precedent-limiting presidential power. In politics, he could suffer reputational damage, alienation of key voters, and intensified scrutiny in ongoing cases. In history, he could be remembered not as a strong defender of law and order, but as a leader who trampled constitutional rights for political theater. But there is also a broader consequence. If Los Angeles succeeds, it will reaffirm a fundamental truth of American democracy. No president is above the law. The Constitution applies not only to ordinary citizens, but also to the most powerful occupant of the Oval Office. Whether through civil suits, criminal investigations, or political judgment at the ballot box, Trump would face accountability for actions that crossed legal and moral boundaries. The road ahead will depend on judges, lawyers, and voters. But one thing is clear. If these raids are proven unlawful, Donald Trump's attempt to project strength will backfire, exposing him not as a protector of America, but as a violator of its most sacred principles.